Welcome to the 19th Century Charitable Association in Oak Park, where it is our vision to be a dynamic cultural center for community learning. Good afternoon. I am Judy Ekberg, Chair of the Social Science Committee and responsible for today's program as part of our mission to strengthen our community through learning, giving, and sharing our landmark building. Today's program is entitled The United States Supreme Court, What's Happening Now and How We Got Here, and is being presented by Professor Sara Konsky. Sara is a clinical professor of law and director of the Supreme Court and Appellate Clinic at the University of Chicago Law School. She represents parties and amici curiae, friends of the court. I had to look this up. In cases before the Supreme Court and other appellate courts. Before joining the law school faculty, Professor Konsky was a partner at Sidley Austin, LLP. Professor Konsky received her BS from the University of Illinois at Urbana-Champaign and her JD from the University of Chicago Law School. She was a law clerk for Chief Judge Mary M. Schroeder on the United States Court of Appeals for the 9th District in Phoenix, Arizona. Professor Konsky is an elected member of the American Law Institute, as well as a board member of the Pro Bono Network. I would like to introduce Sara. Thank you.
Thank you for that wonderful introduction, Judy. It is great to be here at the 19th Century Charitable Association talking about one of my favorite topics to think about and to talk about these days, the United States Supreme Court. I really appreciate the warm introduction and the warm welcome. In addition to what Judy said, I'm also a proud Oak Park resident. Have been here for about 15 years, raising a family and living in this community. So it's especially great to get to speak here in Oak Park today with your terrific organization. Just to add one point of introduction, people sometimes ask, so wait a minute, what is it exactly that you do? Which is a very fair question. I have been at the University of Chicago for about a decade now, teaching about the Supreme Court to our university's law students and running an appellate law clinic. If you've seen Legally Blonde or How to Get Away with Murder, that's kind of the idea. We have law students in their second or third years of law school basically practicing to be attorneys in real cases. Unlike the TV shows, we're not solving murders, but we are working with our students to take cases that have made it through the trial courts. Either they've been through a trial or have been resolved in some other way in the trial court, have made their way up on appeal to reviewing courts, and are now either in appeal in a federal court or before the United States Supreme Court. So our students get to act like lawyers under the close supervision of our clinic's faculty. So it's kind of the best job in the world. It allows me to teach and to work with junior attorneys on important and interesting cases, but also to think about the US Supreme Court at a really interesting moment in its history. So what I had on the agenda for today was a handful of things. First of all, why are we all talking about the Supreme Court? I find in conversation that most people have opinions about the court, have ideas about what's going on, but wanted to help put in context a little bit what's happening now and why this is our topic of conversation. To give you all a little bit of historical context on the court, how it's evolved over time, and how this moment in time compares to other moments in the court's history. To talk a little bit about how the court works. We see the big headlines, we see the big cases, but how do we get from point A to those big decisions? dig in with you on what's really happening now at the court, again, to try to put some of our headlines and news into context for you, and then talk a little bit about a topic that has really gained momentum in the last decade or so, court reform. Is there a way we could be doing the Supreme Court better? So those are our topics for today. Just from some conversations before the presentation, I get the sense there's a lot of questions and a lot of things that people already have on their mind, so would love to leave some time for questions and discussion as well. So to start, why are we all talking about the Supreme Court? As you've probably figured out, the short answer is that it is playing a very important role in our American life and democracy, especially at this moment in time. As you undoubtedly know, the court is deciding cases on major and important issues. So just within the last, 5 or 10 years, we've had big cases on abortion, affirmative action, guns, religious liberties, and more. At the same time, we've seen a lot of executive actions and the court being put in the position or taking itself the position of ruling on those. So we're seeing cases on birthright citizenship, immigration enforcement, removal of federal officers, and much more. At the same time all this is happening, we have a supermajority of justices, 6 out of 9, who have been appointed by Republican presidents. Scholars who study the court and have done studies on its decision have concluded that we have the most conservative court issuing the most conservative decisions in 90 years. And we'll talk a little bit about that later. At the same time this is all happening, we have a Congress that many would agree is largely gridlocked in its ability to do things. So more is falling to the executive to do things through executive actions, and then the court to decide issues itself. So right now at this moment, we're especially paying attention to when the executive and the court potentially collide. What happens when the executive does something and the court has to review it, and specifically on whether and how this court will be curtailing or ruling unconstitutional or illegal actions of our executive. So there's a lot to talk about today and at this moment that we'll be unpacking throughout our conversation today. But I wanted to start with a bit of history on the courts, because I think it helps frame the discussion about what's going on and how this compares to other moments in our court's history. So, I had a slide there that everybody's talking about the court, from podcasts to pop culture to even the New York Times expanding its Supreme Court coverage from having 1 reporter on the court just a few years ago full-time to now 4. So we're in good company trying to unpack what's happening at the court at this moment in time. But let's get to the history of the Supreme Court and its trajectory. As you probably remember from civics and whatnot, our Constitution set out 3 separate branches of government, right? This is your high school civics exam. We have the legislative branch, the executive branch, and then Article 3 sets out our judicial branch. It's actually a pretty sparse article of the Constitution if you go back and read it. It provides that the judicial power of the United States is vested in 1 Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. It provides that justices will serve for life tenure for good behavior and talks about how presidents appoint justices and the Senate confirms them. Past that, not much about what the judiciary actually does. Congress right away enacted the first Judiciary Act of 1789 that did authorize that 1 Supreme Court and some of the lower courts that we have today. And it picked the number of 6 to be the justices, 1 Chief Justice and 5 Associate Justices when we started. But early on, it wasn't exactly clear what they were going to do, and it wasn't a glamorous job. You remember they don't have the power of the purse like Congress. Congress appropriates their money. They don't have the power of the sword like we say the executive does. So these first justices kind of had to figure out what they were going to do. In the early years, they didn't even have a nice building to meet in. I included some pictures there that they were often having to share kind of modest facilities with other bodies or courts. So meeting in state buildings, or in the early 1800s, moving to a small chamber in the basement of the Capitol building. At one point during construction of one of these facilities, they met in a tavern. So they were not in the stately, grand, beautiful building with the marble and the facades that we have now. And it wasn't entirely clear how they were even going to spend their time. Early on, the justices had the duty of what they called riding circuit, which meant they literally traveled across the country on horse to preside over cases that were happening in the country. The account there from the Supreme Court Historical Society explains that they would often arrive either late or sick and miss the arguments. But this was the kind of job that you might think twice about taking. It wasn't the powerful, prestigious job we might think of it being today. But over the next 200 years, we saw a dramatic increase in the court's power over time. For those of you who are lawyers in the audience, and I know there are some, you'll remember the Marbury versus Madison case from 1803. The Supreme Court justices smartly decided in that case that they were the ones that had the power to determine the meaning of the Constitution. So they declared in an opinion that they had the duty as the judicial branch to say what the law is, and effectively to act as a check on those other branches. So from the beginning, we saw the court taking power over legal interpretation and constitutional interpretation in a way that would only grow over time. Many commentators think that we are at a moment now where we could be seeing another shift in the dynamic between the branches, which has occurred over time. It's not unusual to find the Supreme Court or the judicial system in the middle of divisive social issues or in the middle of power struggles with other branches. Some of our earliest pictures of the Supreme Court are from the Civil War or the Reconstruction era. That's one point in our history where the branches were famously at odds with each other or in tension. We had the Reconstruction era Supreme Court infamously resisting some of the congressional efforts to have the Reconstruction Acts that Congress envisioned. So this is the era where we see some infamous cases like Dred Scott, where the court held in 1875 that enslaved people were not citizens of the United States and therefore could not expect any protection from the federal government or the courts. This is a time where we saw the court's credibility in question, and we actually saw Congress taking some actions to try to curtail the power of the courts. Just about 20 years later, Congress was fearing that the court might declare important parts of its Reconstruction Acts to be unconstitutional, and it actually stripped the power of the court to have judicial review over those cases. It raised the number of justices at that point to 9 justices in hopes of getting more that would be sympathetic to what it was trying to do in the Reconstruction Acts. So even within that first century of the court's business, we saw Congress at times and the executive at times trying to exert power and levers over the court, whether it's changing numbers of justices, changing the cases the court can hear, and the like. And those are powers that the Congress does have. Another big shifting point for the court was the 1900s. In the New Deal era, we saw FDR clash with the court over his New Deal plan and famously proposed to pack the number of members on the court add a bunch of justices, one for every person who was over 70 on the court at that time, in hopes of getting the court to stop challenging or ruling that his New Deal legislation was unconstitutional. We saw the court retreat there, where one of the justices ended up shifting votes to stop this court packing plan from going forward and taking down the temperature between the courts and FDR. So this power struggle isn't anything new in our history between the branches, and they've been juggling how they're going to interact for some time now. But we really see the modern expansion of power with the Warren Court in the 1950s. As you probably know, the Warren Court was really at the center of our civil rights movement. This was kind of the opposite of some of the other periods in our history where the court was maybe a bit more reserved and pulling back. Historians largely agree that the Warren Court was propelling forward the civil rights movement. Cases like Brown versus Board of Education, of course, the unanimous decision that racial segregation in schools is unconstitutional. The court ordered schools to desegregate despite the unpopularity of that in communities that were affected, and President Eisenhower, of course, sent in troops to enforce the court's order. And it was during the desegregation controversies and other civil rights controversies that the court again reiterated it has the final power to say what the law is. In the Warren Court era of the 1950s and into the 1960s, we saw the court really expand its power and its reach to all kinds of other civil rights causes. So the courts were then at the forefront of this national effort, deciding case after case in favor of civil rights in our country. We see at this point, decisions regarding integration, criminal law, voting rights, privacy, and a bit later, abortion and other rights like that. And since then, we've seen the court continue to expand its power, largely without pushback from the other branches. Which takes us to today and the court we have at this moment in time. But before we dive way into it, I wanted to talk a bit about how the Supreme Court actually works. I find that it's sometimes hard to glean from news headlines and stories like literally what they do day over day. So I thought we could talk a little bit about how the court's internal procedures and nuts and bolts and everything work. Before starting on this, well, actually, let me advance slides there. Okay, before starting on this, I did want to say there is most certainly a debate about how we should be talking about what courts are. My background is as a lawyer. I went to law school, practiced law, and now teach in a law school. So, my lens tends to be one of the law. When I give these talks with political scientists, they kind of laugh and say, that's really cute, but, courts are really just political bodies, right, that are acting as a branch of politics, and different academics are going to have their lenses they're talking about the court through. Chief Justice Roberts famously says that courts are just neutral referees or umpires who are calling balls and strikes as they see them, using their own judicial philosophies, where critics of that approach say that they are, again, political actors who are making their decisions on something else. So I want to unpack some of that today with you too, but again, start with kind of the nuts and bolts that we can all agree on about what courts are doing. Per the current statutory scheme that Congress has set out, we have 9 justices on the Supreme Court. They are appointed, of course, when there's a vacancy, either because of retirement or someone's passing, typically, appointed on the nomination of the president and then confirmed by the Senate. The court currently has what they call discretionary jurisdiction. At points in our history, the Supreme Court had to take every case that people wanted to take up to it. It was a court of mandatory jurisdiction. it was really busy and really unhappy. And as our country got bigger and bigger and bigger and the number of legal matters grew, it was impossible to have the Supreme Court hearing every single case. So now it's a court almost exclusively of what's called discretionary jurisdiction, which means it literally picks its cases. It can say yes or no, thumbs up or thumbs down when someone wants to bring a case to the court. I have a picture there of the Supreme Court's conference room, and that is where it decides what cases it is going to take. Once a case has been through the trial court phase, so either gone to trial to a verdict if you've ever sat on a jury, or has been ruled on by a judge in some way that ends the case, the parties can appeal to say, we think the lower court got it wrong. In our federal system, there's a whole layer of appellate courts that then review what happened in that trial court. They issue typically a written opinion, and then the parties have the option, if they think there's an issue for the Supreme Court, to try to say, hey, Supreme Court, you should look at this case because we think that appellate court got it wrong. The process for doing that is called a writ of certiorari, which is basically a written submission to the court by lawyers typically, although not always, that explain why the Supreme Court should take the case. They, on average, have been getting 6,000 to 10,000 of these a year in cert petitions. I don't know if you know how many they're granting, but it's a very low percentage of those. Right now, they're around 60. So, in a slow year, you may have 6,000 petitions and 60 cases that they choose to take up for their docket. They decide in this conference room. Each of the justices has 3 or 4 law clerks, typically, who are graduates of law school, often pretty recent graduates, top of their class, stellar credentials. And the clerks have the job of sifting through the petitions to help the justices in evaluating them in the first instance. But it's the justices who meet alone in their conference room to vote and decide which cases to take. When they have their conferences, there's no law clerks, no assistants, nobody taking notes other than them. So they are sitting around a table and deciding what cases to take. They say in their rules that they're looking for a few things. The first is cases where there's a disagreement among courts on a legal issue. So, maybe the courts in California have said one thing, and the courts in New York have said another thing, and the courts in Texas have said a third thing. The Supreme Court is the body that will often step in to resolve those controversies on issues of federal law. They also say in their rules that they'll take cases when they're sufficiently important or when courts are doing something that conflicts with Supreme Court precedent. So they will decide together whether to take a case or not take a case. They don't typically give reasons why, although they have the ability to write a dissent if they want, saying, I thought we should have taken this and my colleagues didn't, but that's pretty rare. Of the 9 justices, interestingly, it only takes 4 to vote yes to take a case. So you don't need a majority of justices to want to take a case, just 4. So that gets us to what we call the Supreme Court's merits docket. That is the bulk of what the Supreme Court's business is in a usual year. The court will issue an order saying, hey, your case is one of the 60 or 70 that we've decided to take this year, and it's off to the races. The parties submit more legal briefing, so typically very well-researched, very thorough briefs explaining the legal issue to the court. The case goes to oral argument then before the justices. This is a peek into the courtroom, but you can see in the back of that photo, there is a horseshoe-shaped bench of the 9 justices. They sit in seniority order, from most senior in the middle to least senior on the sides, and they pepper the lawyers for both sides with questions. If you've heard any of the oral argument audio that the court live streams or makes available afterwards, it is often a very intense hour or so sometimes of questioning for each side on the legal issues in the case. After that, they typically will issue a written opinion explaining their decision in the case, sometimes with other opinions, a concurring opinion saying, I agree, but not for that reason, or a dissent saying, I disagree and would have voted differently. On the court's merits docket, we typically know how everybody voted. Your vote is recorded, so you can see whether a justice was in the majority opinion or was not and was in a different opinion instead. The court's term is from October at the beginning of the term to June or July. So they typically, unlike some courts, if you've been involved in lengthy litigation, get everything done the same year. So all the cases we're talking about today should, barring something unusual happening, be decided by the end of this June or early July when the court goes on its summer recess. I sometimes get the question of, well, how does the court enforce its orders? It says, hey, you can't do this, or hey, this branch of government went too far. And again, the Constitution doesn't give the court an army. They have the U.S. Marshals. If you've been to a courthouse, the security folks who are there and who are terrific. But the answer to the question is that we have largely existed on norms of the court explaining what the law is and the other branches or parties listening to the court. If there is a private party that disagrees with the court, it has tools available to it like contempt of court, using the help of other branches to enforce its orders. But in cases where the branches may be at odds with each other, our system has largely been more norms-based so far. Let me make one other observation for you on kind of what's going on at the courts. You may have heard recently about cases that are getting to the Supreme Court on a fast track. We don't know what to call it. Even the justices disagree on what to call it. I'm calling it today the fast docket, although I don't know if that's great. One of my colleagues coined the term the shadow docket, hence my shadowy picture there. Some of the justices have called it the emergency docket or the interim docket. This is where a lot of the big stuff is happening right now. The idea is this: there's nothing untoward or unusual about courts needing processes to decide cases very quickly. If you think about our day-to-day life, think like a domestic violence protective order or a dispute about property where somebody's threatening to take the property out of the country, right? Courts always need the ability to act very quickly in the face of emergencies. But we are increasingly seeing those sorts of cases at the United States Supreme Court. They used to be, at the Supreme Court, primarily death penalty cases. So if you think about it, somebody has been sentenced to the penalty of death in our country. They are scheduled for an execution, and they want a legal challenge to their case to be heard by the Supreme Court. Often this comes up on the eve of an execution. The court needs a process to be able to say, okay, we're going to deal with this quickly and maybe pause the execution if we need to, because otherwise, if they weren't able to do so, it would be too late for this individual to have a meaningful chance for review. So the process of having an emergency or a fast docket is nothing new or unusual or untoward. What's happening, though, is we're seeing this docket become much, much, much more busy in recent years. And it's increasingly a fact pattern along these lines. The executive will do some sort of sweeping action. So a sweeping executive order on, say, birthright citizenship or on immigration enforcement or on firing of federal employees. And we see parties go to court really fast to challenge those actions. Petitioners in President Trump's second administration have been doing very well in the lower courts. And the lower courts are saying, no, wait, we need to put this on pause while we figure out the legality of all of it. The government has been appealing many of those cases on this fast track up to the Supreme Court, saying, hey, you need to step in right away and decide whether we're going to be allowed to go forward with this action. while the litigation is pending. This has been a big part of the court's docket recently, as we'll be talking more about. And it's really the opposite of how the Supreme Court usually does business. The court's building itself has tortoises in the facade of the marble, and they are supposed to represent the slow and methodical pace of justice from the tortoise and the hare parable. And these fast-tracked decisions are asking the court to make decisions often in a matter of days or maybe weeks. They're fast orders. We don't always get a recorded vote. So we may not know which justices were where, just a thumbs up or thumbs down from the court on whether something can go forward. They're often without opinions or reasoning, and they can pose a lot of challenges because they make it harder for everyone, from the lower courts to the parties themselves, to figure out what the court was thinking or what its reasoning was. So this is an important development when we're talking about the court in just how we're doing business right now. So what's really happening at the Supreme Court now? We have, as we have for our lifetimes, a court of 9 justices, but a world in which judicial appointments have changed significantly for a few reasons. Number one is, as I'm sure you've picked up, we don't know when vacancies on this court are going to occur. Sometimes justices choose to retire at a certain point, often with an eye toward having a president of a certain party appoint their successor. But in other cases, justices serve for life and can choose to serve until they become incapacitated or pass away. Just in the last 10 years, we had Justice Scalia pass away while on the bench, Justice Ginsburg pass away while on the bench. So there's a bit of happenstance potentially as to which presidents are getting to appoint justices and which aren't. 6 of our current justices, a supermajority, were appointed by Republican presidents. Here's a trivia fact that my students always kind of get bug-eyed at. Since 1970, 5 of our justices have been appointed by Democrat presidents, and 14 have been appointed by Republican presidents. And that is largely a feature of happenstance. President Trump had 3 in his first term. President Biden had 1 in his term. To be fair, in recent history, some of our Republican appointees have turned out not to be that conservative once they hit the bench. So while Republican presidents appointed 14 justices since 1970, those included Justices Stevens, O'Connor, Justice Souter, Justice Kennedy, justices that were, to the middle or had shifted, I think it is safe to say, leftward of where their appointing presidents had hoped. As a result of this, though, both parties seem to be focused more on making sure that doesn't happen. That there were individuals in the Republican Party who, after Justice Souter proved to be more independent and left-minded than I think had hoped, had a rallying cry of no more suitors. So as a result, we have seen a different kind of appointment process in recent years. The Senate confirms the presidential nominees to the court. They've gotten contentious recently. This isn't unique in our history. There were other points in our history where it was really ugly. But for our lifetimes, we have seen a certain rise in contention. Justice Scalia, who you may remember was a real lion of the right on the bench, was confirmed unanimously, 98-0. Justice Ginsburg, a lion of the left on the bench, was also near unanimously confirmed at 96-3. Our last 2 confirmations have been near party line votes. Justice Amy Coney Barrett was 52-48, and Justice Ketanji Brown Jackson was at 53-47. So it's just a different tone, even within the last couple of decades. There's also been more tension around getting those nominees for a president. As you may remember, Justice Scalia passed away in February 2016. This was during President Obama's final year in office. He nominated Merrick Garland, who was a sitting judge to the Supreme Court. The Republican-led Senate declined to confirm President Obama's nominee in the election year, and then President Trump nominated Justice Neil Gorsuch, who's now on the court. We saw, as you probably also remember, 4 years later, Justice Ginsburg passed away in September 2020, which was during the final months of President Trump's first term. Then we again had a Republican-led Senate, and they confirmed his nominee, Amy Coney Barrett, to the bench then. There's a lot of debate about what the process should be in these situations. Should a nominee be confirmed if he or she is qualified? Should a nominee be confirmed if he or she is of or if the Senate is of the same party as the president? How should we be looking at these questions? But at a minimum, I think most would agree that this has gotten much more contentious and heated, and a sense that appointments are extremely important since you're putting somebody on a court with a lot of power for life. So that is where we are on the makeup of the court. At the same time, as I was referencing earlier, there is some terrific research looking at the ideology of the Supreme Court that has concluded that our Supreme Court's decisions are the most conservative in 90 years. There is also reporting and polling that many believe the court is too conservative in its decisions, and its job approval is at a near record low year over year. The court historically is one of the more popular branches of our government, but has been seeing dips in its approval rating. There's a lot of reasons why, and I'm sure, having just chatted with some of you before the program, many of you have your own opinions about what is happening and what the court's been up to in recent years, but wanted to try to put some context around what we're seeing from the court and its decisions. A big thing that we're seeing at the court is a willingness to overturn big precedents, right? So if you're talking to people about the court, one of the big decisions on people's minds is typically the Dobbs decision of a few years ago that overturned Roe versus Wade, which had held there was a constitutional right to an abortion in this country. There are other examples of this happening right now, too. This is a court that just in recent years has reversed prior decisions on affirmative action, on issues of executive branch agencies, and has some opportunities to do so again this term on other important cases. To try to put this in context, the New York Times had a good piece recently making the, I think, important point that overturning precedent isn't new or isn't necessarily bad in and of itself. There are examples in our history that we laud, Brown versus Board of Education, which said we need to get rid of separate but equal schools, was overturning a Reconstruction era decision called Plessy versus Ferguson that had said, hey, separate versus equal is just fine. So the idea of reversing course in settled areas of the law, isn't inherently wrong, but the court is raising a debate now about how we should look at settled authority, and has, in some cases expressly and in some cases implicitly, signaled to lower courts and to litigants a willingness to overturn precedents and to go in a more conservative direction, especially in cases on major social issues. What do we make of this? Critics, of course, will say this isn't how the rule of law is supposed to look. This looks political to people. When you say we have a supermajority on the court and we go ahead and overturn a bunch of precedents in favor of more conservative results, that garners criticisms of the court as a political body. Supporters will say that this is how courts are supposed to work. So one of the refrains you hear from conservative scholars now is that the martial courts in the civil rights era, just went way beyond what the Constitution says. So it was finding constitutional rights to abortion and other things when it wasn't in the Constitution, and that this is the court kind of retrenching and correcting its errors using a different judicial philosophy. You may have heard about originalism and the justices that are kind of adherents to the view of originalism say, no. We look at the words the Constitution says and what the framers intended, or what we think the framers intended back when they ratified the Constitution. And if there wasn't a right, or if we don't think the framers would have had this right in mind, then it's not. Then it's not something we're going to recognize today. So I think one of the ways we can think about what's happening right now is, again, through kind of these different lenses of, political scientists would tell you one thing, people tell you another thing. The legal doctrines, the legal philosophies, the legal reasoning may get you different places as well. But at a minimum, we're seeing a big upheaval, potentially continuing, but certainly in the past recent years on important precedents. At the same time, we are seeing the court keeping very, very busy on its emergency docket. The Trump administration, as we know, has been very active in executive orders and other actions. And one website tracking challenges to the Trump administration's policies counted 613 separate lawsuits challenging Trump administration policies. This was as of a week ago. I'm sure the number is higher now. And you figure if just a fraction of those 613 cases make their way up to the Supreme Court on its fast track, that's going to keep them busy. So far, we have seen emergency docket cases just in the last couple of years on everything from immigration enforcement to federalizing the National Guard to funding SNAP benefits to firing executive employees to congressional maps. The administration is doing extremely well in these cases. They are largely following a pattern where lower courts may be saying, hey, we need to put on the brakes. We're going to put the pause on this while the litigation proceeds. And often the Supreme Court is saying, no, we don't need to put the brakes on this for one reason or another. There's a lot of things going on in these cases. Some of the Trump administration's success can likely be explained by the fact it's not choosing to take everything up to the Supreme Court. So it takes some losses in the lower courts and doesn't appeal it up to the Supreme Court. So I adhere to the view that they're probably being strategic in what they're taking up and what they're not. There's some cases where this gets a little complicated legally, where the court is deciding very preliminary matters in these cases and not kind of ruling on the later issues. So in the birthright citizenship case, for example, it said certain technical things about how the case had been brought, but hasn't yet gotten to the birthright citizenship issue itself. So we're seeing some of that sort of thing happening as well, where the legal kind of ins and outs of the cases may matter a little bit, but it also may be just more telling, as the Wall Street Journal's piece here explained. President Trump's policies got a big boost from these emergency appeals. And as the cases continue to work their way through the system, we'll have to see whether the court starts to rein in on any of this or whether it continues down the path it is down now. But that's just the emergency part of its docket. The court also has, just for this term on its regular docket, birthright citizenship, the imposition of tariffs, the independence of the Federal Reserve and other agencies, the constitutionality of state laws banning so-called conversion therapy, the constitutionality of state laws regarding transgender athletes in sports, the constitutionality of more firearms laws, and voting rights and elections issues. That is all this term. So I used to give these talks at the university where they would say, hey, talk about what the Supreme Court's doing this term. You might be struggling to find like one or two cases that were kind of interesting. A good year, you'd maybe have 3 or 4. This is going to be another blockbuster term for the court with these decisions to be, we expect by June or July. I agree with commentators who say that this court is going to face some very big decisions this term. And some of the executive actions that it's facing go a lot farther than the other ones that it's seen so far. So the birthright citizenship order, for example, the independence of the Federal Reserve. We've seen some signs in oral arguments that there may be an appetite for reining in some of these executive actions on the court, but we won't know until the opinions come out exactly what it looks like. I think this term will help to give us a very good sense of what role and why the court will be playing during President Trump's second administration. I sometimes get the question, like, why are they doing all of this? Why are they taking these cases? As I mentioned earlier, it's a discretionary docket. So in some cases, they've chosen to take the cases and presumably want to. In others, it gets a little more complicated. This is a period in time where there are a lot of really important issues percolating in the lower courts. Sometimes they may feel, I'm speculating here, they may feel their hand is kind of forced. And if there's, big decisions below, they as the Supreme Court need to decide them. Some of the decisions were from the last terms as well are just creating new legal issues. So I predict we're going to continue to see a lot of cases about religious liberties, about guns, those sorts of issues. And those are largely stemming from these really big decisions from recent years. The court says, let's look at a legal problem differently. It issues a very big decision, and it kind of creates more questions that linger. So I think, I would predict we'll see a lot more gun cases, religion cases, First Amendment cases in years to come as well. I want to leave enough time for questions, but wanted to say just a little bit about what the discussion has been around court reform and changing how we do things at the court. So what's the deal with court reform? A few things. When President Biden was in office, he had a commission that he tasked with evaluating issues of court reform in our country. This was right after some of those kind of contentious nominations of the Biden administration, where Democrats were saying, hey, we should do something about the court. President Biden's commission was 36 or 7 academics, including 3 of my wonderful colleagues, and it issued a very thorough an interesting report that is very academic in tone, perhaps not surprisingly. It did not, recommend kind of sweeping broad changes, but it studied them and is a very comprehensive kind of explanation of things that might be done with the courts in the future. I will offer a few thoughts. By far, the most popular reform to our court system with people is term limits or mandatory retirement ages for justices. We are very unique in major democracies in not having either a retirement age or term limits for our justices. So this is one that I suspect will continue to get a lot of discussion. We have thoughtful writings in recent years, including this one from my colleague, Judge Wood, who was the chief judge of the Seventh Circuit Court of Appeals in Chicago and is now back teaching at our law school, about term limits make sense and can be implemented by statute. That's the big question here, though. As you probably remember, our Constitution says justices serve for life tenure. So, some skeptics say we would need a constitutional amendment. Really smart people are explaining, maybe not. Maybe there's some workarounds where we could appoint you for life, but then just have you cycle in and out of the Supreme Court or other proposals like that. I anticipate we'll continue to hear more about term limits or retirement ages going forward, though. Other examples of reforms we hear talk about would be membership and size changes to the court. Remember, that's Congress. They can add justices whenever they want. The court's role in our constitutional system is actually more or less set by Congress as well. They decide what cases the court takes, what its jurisdiction entails. So there have been some discussion of reforms we could have there. And then reforms to the court's procedures and practices. In recent years, you may remember some discussion about the need for ethics codes or reforms on our Supreme Court. The court itself issued a document that was kind of a guidance to the justices on what they should be doing and disclosures and whatnot. But that's another area where the Biden Commission and others have talked about things we might do differently at the Supreme Court. In closing, that's all up to Congress for now, at least. But I would anticipate we'll continue to hear discussion about court reform, especially if the court continues on its current trajectory. So my takeaways would be a few. Number one, eyes are going to be on the Supreme Court this term for good reason. So what I would encourage you all to keep watching. It's going to be a big term with big cases. And I think it's going to be a important test for us all of whether and when the Supreme Court is going to say the executive's gone too far in some big cases. And I guess regardless of how those cases come out, what the executive's going to do in response. So we think we will know more, again, within the year. More broadly, it seems not improbable that we're at another inflection point for the courts in our history, where we're going to be watching its important and evolving role at this point in time. And can expect the court to be continuing to impact our daily lives as well as our democracy. So I'd encourage you all to keep paying attention, encourage folks to stay informed and engaged, and stay attuned to these issues, as I think they're going to be increasingly important in the short and the long term. So that's all I had in terms of kind of prepared remarks. I know this is a topic that a lot of people have a lot of thoughts on, so I'd be very interested in questions or whatnot if anyone has them.
Is the court influenced at all by public opinion?
Oh, it's a great question. Is the court influenced at all by public opinion? I heard a no. So I think it's important to start with the notion that the justices are not a monolith at all. They are 9 individuals in different, social circles and different political, legal theory beliefs and the like. Do they look at the opinion polling and say, well, 2/3 of people disapprove, so we should vote differently? It doesn't look like it, so I definitely agree with the no in that regard. What we hear more and what seems right to me is that the justices are going to be influenced by those in their circles. If you are a conservative legal scholar and hanging out with other conservative legal scholars, you're probably going to care what they think of your opinions, in the same way that if you are part of, certain progressive circles, you're going to perhaps care about what people in other progressive circles think. So that's one explanation you hear that seems plausible. There has been a fair deal of discussion about Chief Justice Roberts and his role as the chief, being concerned about the institutional legitimacy of the court, how the court is perceived, how it's respected and all of that. So, that seems like it could be coming into play in some cases as well. They're not immune to all of, the things we're talking about. There's been reporting that some of them have social media accounts that aren't public and are reading things. Their clerks are reading things. So I would anticipate they are influenced by public opinion in some ways, but exactly how is very hard to quantify.
What methods, how are the justices themselves held to account for their conduct?
The Constitution says that the justices serve for life tenure for good behavior. Good behavior in our history has, you have some cases where judges have stepped down for really bad, sexual misconduct sort of things, but past that, they have not. So the lower court judges themselves don't have the requirements of good behavior have not been enforced in the way we might think of in other sorts of jobs. And the justices themselves, can be impeached, but past that, there's not much. As an independent branch of government, they've taken the position that judicial independence would be at threat if they were more regulated.
What's in place for our so-called president to defy lower court rulings that he just seems to pay no attention to, and we hear no more about it as to his feet being held to the fire for not adhering to lower court rulings?
Yeah, that's a terrific question that raises a number of different considerations. So let me try a few things. Number one is that our courts over time have established the idea of judicial supremacy in our country, the idea that the courts get to say what the law is and the other branches respect that, right? It's kind of norms-based, but throughout our history, we've gotten to that place, right? So the court says in Brown versus Board of Education, you need to desegregate schools. President Eisenhower sends in the guard, right? And we listen to the courts. So as a starting point, there are some in different kind of conservative legal scholarship circles who say that's not a foregone conclusion, that, sure, the courts can say what they think the law is, but then the executive should also be able to say what it thinks the law is, and the legislature should be able to say what it thinks the law is. So I would start by we're seeing some more discussion in recent years, perhaps not surprisingly, of what the role of the court should be vis-a-vis the other branches. Second, I heard one of your fellow guests kind of commenting that this kind of turns on consequences. So, if there are questions that have been raised in everywhere from academia to pop kind of media, what happens if an executive defies a court order, right? And we've fortunately, I'm going to say knock on wood, not had many examples in our history where that's happened. And the ones that have been kind of a long time ago and unique in a number of ways. But if, worst case, if the Supreme Court says, President, whomever you are, you need to do this, and the president says no, it's not entirely clear what happens next. And we have fortunately avoided that to date. But the president has the army. The justices have some marshals, and the marshals are great. I don't mean to. The marshals are fabulous, but they're not our army. So there are really important constitutional questions lurking there. You've heard this administration say kind of off the cuff, well, we'll listen to the Supreme Court, but we don't agree we need to listen to lower courts. That's new too. So we are kind of exploring some of these new questions as we go, since we haven't had to confront them before. So far, unless I'm forgetting something, the court has been fairly restrained in when it's challenged this administration, on the big kind of issues. But if I'm thinking of this correctly, there haven't been examples yet where the administration has kind of blatantly just said no to a Supreme Court order. But there's nothing stopping this administration or another one down the road from doing that.
Have there been any Supreme Court justices that have been impeached?
I was afraid you were going to ask that question because I don't remember the answer. I think there potentially was one or two a long time ago, but nothing recent.
What did John Adams think about the warrantless and interception of cellular communications?
Exactly. So
Doesn't that mean originalism is not tenable?
So I do not pretend to fully understand the doctrine of originalism. Let me try for those of you who haven't had the opportunity to think about this. The exercise that a majority of the Supreme Court wants us to undertake in some context now is to look back at the time of the framing to what the framers intended. To the excellent question, we aren't living in the 1700s anymore, right? And the world has just really changed. The court's grappling with this itself. One of the great examples is the Second Amendment jurisprudence. A few terms ago now, maybe it's been more than a few, I'm losing track of time, the court decided a case called Bruin. And it said then when we're looking at the constitutionality of gun regulations, we look back at the time of our framing, when we passed the amendments to the Constitution, and we try to think about whether this is the kind of law the framers would have wanted to say thumbs up or thumbs down to. So when you think about it, you might say, okay, that sounds like okay. It's really hard to figure out how to do as a practicing lawyer in practice. So, the court decides Bruin about guns, and in successive terms, we have a case about, okay, what about somebody who has a domestic violence restraining order? Can we keep them from having a gun? We weren't so concerned about domestic violence, unfortunately, in the late 1700s. So, we wouldn't have even had domestic violence restraining orders. And you see the court grappling with the history and analogies, and both sides are saying, well, this is kind of like mental illness. No, it's not. It's kind of like civil disobedience. No, it's not. And kind of grasping for the most perfect analogies. And it just results in a lot of litigation. So we're seeing gun cases term over term. The Fourth Amendment is another example when you're thinking about the original meaning of the Fourth Amendment, which prohibits searches and seizures. Again, we were talking about houses, horseback, all this. We weren't even talking about cars, much less cell phones, much less, technology. So I'll say as a practicing lawyer, it's a challenge to figure out, how to do good originalist research. We're all trying to learn. And then, what to make of originalism as a legal philosophy. I suppose I won't give you my full opinion on that, but it's a difficult one to implement, especially as a non-historian.
So you talked about 1,000 cases being appealed every year to the Supreme Court, and only 1% are taken. So what happens to the other 99%? Are they settled cases, or can you appeal them every year? Or
that's a good question. I should have clarified that. You get one shot. So in our federal system, which is where most Supreme Court cases are coming from, you go through the trial court, and then you go up to the Court of Appeals, and the Court of Appeals will issue a decision, giving a thumbs up or thumbs down to the trial court. If you don't like what happened, you can try to take your case to the Supreme Court. If they take it, they review it anew, so those 60 or 70 cases get another look from our U.S. Supreme Court. If your case isn't taken, it's just done. So whatever happened in the Court of Appeals is the final decision.
I was wondering, the court has expanded the purview of the executive and said that they are immune from any sort of legal action, and that the only remedy is impeachment. So to the earlier question about whether or not the president obeys a Supreme Court order, wouldn't the answer be that the only remedy is impeachment?
It might be. The court held, a term or two ago, I'm again losing track of time, that the president has absolute immunity for official actions taken in the presidency. So maybe that is the right answer, that if the president himself just says, no, I'm not doing this pursuant to my executive power, that would be that. It's a little bit tricky. As one of my students pointed out once to me as I was trying to explain something, they're like, well, doesn't the Supreme Court get to say what it thinks the law is? So you might get some interesting headbutting where the executive would say, I have executive immunity, and a court saying, well, not as to us, you don't. So I don't know, but your point it's a point well taken.
What is the main good source to follow the Supreme Court?
If you're looking for kind of a mainstream look at what's going on, the major media outlets have gotten very good at covering the court. So New York Times, Adam Liptak and his crew, Wall Street Journal, I would have said the Washington Post, but I don't know what's happening there these days. Slate. Slate has excellent coverage and a podcast. So if you're looking for kind of the baseline, I would say those. If you want to get nerdy and kind of go in a deeper dive, a few ideas. There's a lot of niche reporting on the Supreme Court right now. There's a website called SCOTUSblog.com, so SCOTUS, Supreme Court of the United States, blog.com, that is a deep dive into legal happenings at the Supreme Court. There are some terrific podcasts on the Supreme Court as well. There's one called Strict Scrutiny that is some terrific women law professors who have a blog on or have a podcast on what's going on at the Supreme Court. Dahlia Lithwick at Slate has a terrific podcast on the Supreme Court called Amicus. And there are a number of other great podcasts. So if you're like me and commute by car, those can be a great way to catch up on what's going on. But I would say to start trying to get a balanced, pick some kind of more right-leaning sources and left-leaning sources from the mainstream media. And I think they're doing a pretty good job with their coverage these days.
Thank you.
Thank you. It was great to be here. Thanks.